spend some time today talking about the National Interest Waiver Green Card, also known as the NIW. This is an underutilized category and one that we've started to see more and more people use to successfully get a green card, in particular in the entrepreneur category. A few things to go over before we get started. Scott Legal is a full-service immigration firm, and we focus on a number of different types of visas, including visas in the NIW category. We will continue our webinar series, doing at least 2 webinars a month on different topics. At the end of this webinar, we will send out a few things. So one is the PowerPoint that you'll see today. The other is a comprehensive guide to the National Interest Waiver. And then you'll also receive a link where you can sign up for additional webinars. For our panelists today, we're very lucky to have Jie Wang, who is an associate at Scott Legal and has vast experience in the NIW area. I will also be presenting, and my name again is Kelly LeGrand-Wiener, and I'm the managing attorney of Scott Legal. If you have questions during the presentation, please go ahead and send them through the chat box. We will, either answer them as we go if it's relevant to that particular topic, or we'll also reserve some time at the end to discuss any questions that come up. Finally, this webinar is being recorded and will be made available on demand. So now we will go ahead and get started. So the first thing we're going to talk about today are the National Interest Waiver requirements. The National Interest Waiver is a green card category that is processed under the EB2 category, employment-based 2. And for a threshold requirement for this category is that you have either an advanced degree, meaning a master's degree or higher, or its equivalent, which would be a bachelor's degree plus 5 years of post-baccalaureate progressive work experience in the relevant profession. If you do not have a degree, the master's or the bachelor's plus work experience, you can also qualify for this category using exceptional ability. Exceptional ability is defined as a degree of expertise significantly above that ordinarily encountered in the sciences, arts, or business. So it's somewhat different from another term you hear a lot in the immigration field, extraordinary ability. So extraordinary ability is kind of a higher level than exceptional ability. However, for exceptional ability and extraordinary ability, there is a 2-part test that you go through where USCIS will first look at do you meet the regulatory criteria? So here, to meet exceptional ability, you have to meet at least 3 of 7 criteria. Academic record showing you have a degree, letters documenting 10 years of full-time experience, membership in professional association, among others. So what they'll look at is, for example, are you a member of a professional association? Yes, that satisfies the criteria. But then in the second part of their analysis, they'll consider whether the membership is the type that indicates that you have a degree of expertise significantly above that ordinarily encountered in your field. So it's really not enough to just meet the criteria. You have to also show that second part, that not just that you have membership in an association that's relevant, but that membership is prestigious, that it's difficult to obtain entry, that it's not the type of membership where you just pay a yearly fee and anyone can become a member, but you actually have to have demonstrated some level of expertise in your field to attain that membership. So once we've kind of met the threshold requirement, then we move on to the actual national interest waiver part. So in kind of a more or a different process called the PERM process, if you're doing an EB2, you have to meet this threshold criteria, and then you have to have an employer, and that employer has to test the U.S. labor market to see if there's any willing, qualified, or available U.S. workers in something called the labor certification process. When you're getting a national interest waiver, what you're essentially doing is asking the government to waive that labor certification requirement. And so in order to qualify for a waiver of that requirement, you have to show that you're engaging in a proposed endeavor that has both substantial merit and national importance. So you need to prove both of those. Then you need to show that you yourself are well positioned to advance that proposed endeavor. And then finally, the third is that on balance, you need to show it's beneficial to the United States to waive the requirements of the job offer and thus of the labor certification that we discussed. So that is something we'll discuss a little bit more later, but one benefit of the National Interest Waiver is that you either can have an employer who's sponsoring you, or you yourself can self-petition. All right. So let's talk about how the National Interest Waiver can be used for entrepreneurs. So in recent years, a few years ago, there was a change to the standard for National Interest Waivers that made it overall generally friendlier for entrepreneurs. And other policy changes since then have even kind of advanced that further to show that this is a category that they do anticipate also being used for entrepreneurs, even though traditionally you may think of it more for, scientists or researchers or people in that, line of work. It also can be used for business people. So in this case matter of Danazar that changed the standard for the National Interest Waiver, there were a few important things we want to highlight as helpful for entrepreneurs. So one is that the benefit to the United States interest, when we talk about substantial merit and national importance, it can be local. So meaning hiring employees in a local area may satisfy parts of the, substantial merit and national importance prong of the Danazar test. So they specifically moved away from focus on a large geographic scope and pointed out that, for example, if you were hiring workers in an economically depressed area, this is the type of thing that could potentially be of national importance, even though you're not hiring nationwide. Hiring in an economically depressed area is of national importance to the United States. So kind of narrowing the scope from saying, the geographic scope, I think was, a helpful thing. So another thing they pointed out, entrepreneurs are self-employed. Often they are not eligible for green cards under the normal labor certification process because of that self-employment and because of their ownership of the company. So entrepreneurs can actually use the fact that it's essentially, impractical or oftentimes impossible to obtain a green card using the normal labor certification process to show that on balance with other factors, it's beneficial to waive the requirement of the job offer and the labor certification. Another thing to note is that Danazar specifically points out that entrepreneurial work can lead to a national interest waiver and states the planned venture does not need to ultimately succeed as long as the applicant can show it's more likely than not to succeed. And generally, you're going to show that through kind of a track record of success, ideally, for the applicant. But you can also include things like, business plans. So you don't have to already have an established and successful enterprise to qualify for the national interest waiver. If you're starting up a brand new enterprise, potentially you can, still go for the national interest waiver, but you do need to have a track record of success. So it's very, often we're asked, do entrepreneurs need an established company to qualify for the NIW? And the answer is no. It is possible to apply with a startup, as they indicated here. They're open to the fact that there's some level of speculation when it comes to these type of entrepreneurial ventures. And they acknowledge that many, may ultimately try and fail. But the applicant just needs to show by the preponderance of the evidence that they are well positioned to advance the endeavor and that it's more likely than not to succeed. So again, like if you have an entrepreneurial history and a good track record in your field, and now you're starting up a new venture, that's potentially something you can, work on or look at for the NIW. We're also asked a lot about kind of the pros and cons of applying with an established company versus a startup. So, if the established company has a track record of success and job creation, that's obviously a huge pro in favor of an established company. A con can be that if you have a company that is not doing very well, you're going to have a harder time convincing them, that you're going to ultimately make it a success in the long run. Whereas if you have an established successful track record and now you have a brand new startup, you're able to rely a bit more on your track record plus the business plan. And we'll go over some more specific examples later that kind of discuss in more detail, how you can rely on a business plan, rely on financial projections, and those are things that can be really crucial to your application for NIW under the entrepreneur category. All right, so let's talk about timing and some considerations when moving from a non-immigrant visa to a national interest waiver, green card. So at this time, I need to update this slide a little bit. There is some premium processing now available for the I-140, but it's still being rolled out in stages. So it's not like if you were to file a brand new I-140 today, premium processing is not available for the NIW. There are certain, I believe, ones that were filed, back prior to I think June 2021, or perhaps sometime in 2021 or earlier. There's certain I-140s that you can actually now submit to premium process, but and they are going to eventually, I think, make premium processing available for NIWs generally. That is the direction, but not yet. So at this current time, it's still correct that there's not premium processing available for new NIWs. What this means is that your petition may be pending for several months, even upwards or over a year, based on the current processing times. And so if you have underlying status, like if you're on a non-immigrant visa, you want to consider, does it allow for dual intent? So if you're on a visa like a TN or an E visa, those visas are really not dual intent visas, particularly the TN. The E is a little bit friendlier, but the TN is really not. And for those visas, you want to be very careful about when you file your I-140. You don't want to kind of have your file your I-140 and then immediately have to renew your TN because the TN, if you have an I-140 pending, it's potentially something that could come up. And if you have immigrant intent, then you may not, not be eligible or not be able to extend your TN or even your other visa. So you want to just consider, when do I need to renew my underlying work visa, and how am I timing the filing of my I-140 to make sure I'm not having any issues with those renewals. So for the application process, you submit Form I-140 with proof that you meet the qualifications. If you're in the United States in valid status, that's not on, the certain statuses won't apply, like ESTA, then you may be able to concurrently file the I-140 and your green card application together. You may also choose to file the I-140 standalone by itself, and then eventually consular process to get a green card outside, the United States at a U.S. consulate abroad. It's, filing the I-140 by itself doesn't give you any status in the United States. So if somebody's here and they don't have that underlying status and they want to be able to stay, then concurrently filing can be helpful, because you can also apply for work and travel authorization to allow you to stay here while the petitions are pending. That being said, when you file concurrently, if you don't have underlying status, you cannot leave the United States, you cannot travel, and you cannot work until you actually get the work and travel authorizations granted. And those petitions themselves can take several months. So you would, like when you are planning to file the I-140 and the I-485 concurrently, you want to make sure that you're planning to be able to stay in the United States for that period of time before you get your travel authorization. There are some limited exceptions for people on H and L visas, but you want to always speak to your attorney before any travel when you've filed an adjustment of status green card application to make sure that you're not jeopardizing, that petition. For people, many of our clients, if they, perhaps they're on an O visa and they need to travel abroad a lot, they're in and out all the time. In that case, consular processing can be a better option because it doesn't restrict you to have to stay in the United States and wait for that travel permission. I think, in terms of kind of pros and cons of adjusting status versus consular processing, for people that really have their lives in the United States, want to stay in the United States, or find staying here for long periods of time, the adjustment of status will often be a better route. For people who's either are traveling frequently or their lives are still primarily abroad, consular processing may be a better option. Additionally, if you're here on a visa that you want to kind of keep, like let's say you were here on an E2 visa running your company and your job requires you to travel abroad a lot, in and out of the United States, you may not want to file a green card application, because once you file that, your E-2 essentially is not useful to you anymore. You have to wait for a travel authorization document from the government, and then you have to use that to travel. If you leave and you travel on your e-visa, your green card application will be abandoned. So it really is specific to your current situation, and it's something you definitely want to discuss in detail with your attorney to make sure that you have the right strategy for whether you're pursuing an adjustment of status or consular processing. Another thing to keep in mind is the NIW applications. They do require lots of evidence, and they're difficult applications to get approved. You do need to meet a high standard. So you may not want to file your green card application, because if the I-140 is denied ultimately, and that may be pending for over a year before you find that out, now you also have a green card denial on your record. So these are just kind of considerations to go through with your attorney as you figure out which route to take in terms of adjusting status or consular processing. Sometimes people also ask, can your family members apply with you? And the answer is yes. Your spouses and your spouse and your children who are under 21 and unmarried can apply at the green card portion of the application. So if you're in the United States, that means when you file your I-485, they can also file their own I-485s with you, as long as they're in the United States in valid status. And if you're applying abroad at a consulate abroad, then when you apply there, they can also apply with you to get the green cards at the consulate. Right. So now I'm going to turn it over to GA to talk to us about what is included in NIW submission.
Okay, thank you, Kelly. So let's talk in detail a little bit about what an NIW submission typically looks like. And I think it is important to emphasize here that the NIW is a very document-heavy submission, and the petitioner, the applicant, bears the burden of proof to persuade the USCIS officer not only that they meet the threshold requirements of having an advanced degree, and having prior work experience if you are meeting the advanced degree threshold with a bachelor's level degree plus 5 years of progressive work experience, or that you have exceptional ability, which is shown by showing meeting at least 3 out of the 7 criteria, and also having also that you do have exceptional ability. It is important to make that distinction in general. So proof that you meet the threshold requirements. If you are meeting the threshold with an advanced degree, you do want to submit your diploma, a copy of your diploma and transcript if relevant. And if your university is from a foreign institution, you do want to include a foreign education equivalency report that you can get from a US agency that shows that your degree, if it is a master's degree or above, or if it's a PhD degree, that it is equivalent to a US institution's PhD degree, master's degree, or any other degree, MBA, that you are qualifying under. For prior work experience, just including your resume is not sufficient. You do want to get letters, official letters from company letterhead, that includes what your duties were, the periods of your work, and if you are trying to meet the standard of progressive work experience, you do want to have an outline of how your duties changed over the years, how your salary changed, and how you took on increasing responsibility that will constitute progressive work experience. Now, after you have submitted evidence that you do meet the threshold requirement, the meat of the petition is really including information that persuades the that can persuade the USCIS officer that you do qualify for the National Interest Waiver. And for that, we want to submit enough evidence that both support prong 1, which is that your specific endeavor, which in a lot of cases for entrepreneurs would be in business, that has substantial merit and national importance. And 2, for the second prong, you want to submit enough evidence about yourself, your credentials, your work experience, and your record of success that will persuade the USCIS officer that you as an individual are indeed well positioned to run your business and realize those substantial benefits that you argue that your business will bring. So let's talk about what kind of documents that you could search for in collecting all of these evidences for your petition. So for the first prong, substantial merit and national importance. Now, one thing that you can do is search for news articles, academic papers, market research, and other objective third-party evidence that shows significant public interest in the area of work that you're doing, or generally in the area that you are proposing to introduce advancements in. So for example, a good example is for environmental sustainability. Now, there are plenty of government agency reports and executive orders that talk about how much the US is committed to advancing new technologies that can help the society achieve more environmental sustainability, achieving net zero emissions in the next few decades. So if your specific business plans to contribute in a major way to that area of that the government is clearly invested in, then you do want to include these captures, PDF captures of these governmental announcements, executive orders, press releases, news articles that show this substantial public interest that is related to your work. Now, another way you can support the national importance of your work is through expert letters. And for those, in order for these expert letters to be powerful, you want to make sure that you will be getting them from individuals who are in senior positions in academia, in the industry, in business, professional organizations, or governmental agencies. And if you can get a letter from those people holding senior positions confirming that what you are doing with your business is in the national importance, then this can be another probative support that you can include to prove national importance of your work. And by national importance, we want to emphasize that the impacts of your business do not end with benefiting your immediate clients. We want to show substantial benefits that go beyond the benefits of the clients who directly use your services, use your products. And one key phrase that a lot of petitioners may use is substantial positive economic impact. Now, aside from the technological factor, there is also an argument that we can make on the economic part of the influence of your business. And by that, I mean job creation. By that, I also mean revenue generation for the local economy. And you can get an economist who has experience in statistical analysis to look at your business plan and extrapolate how much positive economic activity that your business can generate. And this can help provide another way to prove national importance, basically by proving that your business will create US jobs and by doing so create substantial positive economic impact. That is sort of the catchphrase that we'll be looking for. So the second part of supporting your national interest waiver petition will be talking about yourself, the petitioner, applicant as an individual. And what we want to prove here is that you yourself have the relevant skills, the record of success, and the specific experience that make you specifically the best person to handle the business plans that you are advancing. So for that, we want to definitely include your resume, copies of all degrees that you have, even if it is not the same degree that you're using to qualify for the advanced degree threshold. You want to include any copies of academic papers you have authored, any patents you have authored, with an explanation of whether they were cited or used by other professionals in your industry, if you have given presentations in conferences in your industry, and if you and your comments have been reproduced by media articles covering your industry. We definitely want to include that as proof of your influence and the influence of your work that you already have proven in your industry. So if you have a proven track record, the more persuasive it is that USCIS will see that you are indeed the person who is well positioned to tackle this work. Now, one powerful way that you can supplement this record of success is by expert letters. And so, as I mentioned before, expert letters are a powerful tool to prove that your specific endeavor is of national importance. Now, you can also have these experts talk about your prior projects, work that you have done that is related to the work that you're proposing to do and which has already seen commercial success, or if the results have been discussed by other experts in your field and generally have been taken to result in positive impacts. You can also include these case studies, explanations of what you have done before in those expert letters. And this will give the USCIS officer more reason to believe that since you have already seen success in similar and related efforts, your proposed startup or your proposed business that you propose to continue will continue to be successful and also provide benefits that go beyond the immediate confines of your business and its customers. Another pieces of evidence that could be helpful for entrepreneurs is to include proofs of contracts, letters of intent that show that there are already potential clients who are interested in your work. And this proves that there is significant public interest in seeing that your business continues in the US and eventually succeeds. So showing that demand is also another indicator that you are well positioned to handle this endeavor because you have already done those negotiations, and those potential investors or those potential partners in your work already see you as a credible partner in this entrepreneurial endeavor. So that can support your the second prong that you are well positioned to advance your work as well. All right, so now what we will do is go into detail, a little bit further detail on a case study where the Administrative Appeals Office, the AAO, affirmed, actually flipped the decision made by the original reviewing officer and instituted an approval for an NIW petition that was that originated from somebody who proposed to set up a small consulting firm in the US. And that consulting firm aimed to provide consulting services around how to improve the provision of services to US veterans in particular. So it was a very specific service that the consulting firm sought to provide. And it is interesting that the AAO described the endeavor as a small consulting firm, which also gives us the understanding that the size of the business is not the only determinative factor in determining whether an endeavor has national importance. Right. So what happened in this case? So an interesting fact to note about the applicant is that this person as a consultant had around 10 years of experience in the field of advocating for veterans' healthcare, healthcare physically and healthcare mentally. So this person served on US, UK Veterans and Family Task Force and played a leading role organizing campaigns, organizing networking events in this community. This person also had plenty of experience representing the interests of this community in conferences organized under this theme. And what he proposed was to form a small consulting firm in the US where he would take projects and advise US governmental agencies and other stakeholders on initiatives aimed for improving programs delivered to US veterans for the goal of facilitating veterans being reintegrated and returning them into members of productive society. So to support the first prong, which was the substantial merit and national importance of his proposed endeavor, what this applicant included in the record was letters from prospective clients that shows that there was actual interest in his services. He also included a business plan for his company, which gave plenty of detail about the intended client base and what kind of services that his business would eventually provide. Now, to also support the national importance of his endeavor, this petitioner submitted news articles and research reports describing the problems and issues faced by returning Iraq and Afghanistan veterans and the necessity of ensuring adequate services for the physical and emotional well-being of these veterans. So another type of evidence that this petitioner included was expert letters from individuals holding senior positions in the military, government, business, and philanthropy organizations that confirm that this issue was very important and confirm that what this petitioner planned to do would advance these matters of national importance. So considering all of these elements in the record that the petitioner submitted, the AAO concluded that the petitioner's proposed endeavor indeed had substantial merit and national importance. On the second prong, whether this person was found well-positioned to advance the proposed endeavor, some of the evidence that this petitioner included the following. Expert letters, again, describing his expertise and record of success in his past work relating to Veterans Affairs. And in these expert letters, the AAO focused on examples of his past projects, and these letters also outlined the positive impact that these projects resulted in. For example, in one of the letters, the referee quoted, "I know of no other task force member that has the connections and understanding of these charitable sectors and the ability to turn that understanding into results. Tangibly, this has meant that the petitioner has enabled millions of dollars in charitable efforts to be productively connected with service organizations, and without him, we would not have made those links." So these letters clearly prove that the petitioner not only played a leading role in organizing these initiatives, there was also quantifiable benefits, positive impacts that resulted from his work. So the AAO found that those examples were probative in demonstrating that this petitioner was indeed well-positioned to advance his proposed endeavor. So regarding his future work at the company, the petitioner identified potential clients, made sales and staffing projections, also submitted a detailed operating budget with the business plan, and also included financial statements, which demonstrated sufficient funds to cover the startup costs of the company. So it is important that, given these strong evidences of the national importance of the petitioner's endeavor and the fact that the petitioner was clearly well positioned to advance his endeavor, the AAO approved the petitioner's NIW application, and this person was able to continue his work, high impact work in the United States. Okay, so I hope this presentation was helpful for all. Let's move on to questions and answers.
Thank you so much, Jay. That was very helpful. So it looks like we actually, don't have any questions other than the ones we went over during the presentation. So I think we will wish everybody a good afternoon. Thank you so much, for participating. Jay, thank you for all of your insights, and we wish everybody a great day. Thank you.
Thank you.